I can't even go to them with that because I can't make the math work. I just can't. I think I'm pretty good at it, but I just can't make it work where you would even be able to get this clear before the end of the month. Get these out of the way. Court does call the case of Arbor Knoll versus Jordan Sumter.
Good afternoon, Your Honor. April 7 State Prime for Arbor Knoll.
All right. And Jordan Sumter, Dacia Snodgrass.
Yes, I'm here. I'm on behalf of both of us.
Wow. And your name is?
Dacia Snodgrass.
Okay. And where are we on this case? She was to pay $1,000 by the 10th. Did you get that paid?
No.
As of 10:33 a.m. today, no, it has not.
Okay, what happened?
We decided that we're just going to move out. We don't have the money to pay it. So we're just going to move within like a week.
In that case, Your Honor, that you enter judgment with the
Court finds that there's no tribal issue. Court will issue a judgment. Total amount including cost.
$1,905.21.
$1,900
$5.21.
Court will enter a judgment for possession in that amount. Again, finding no tribal issue with a writ in 10 days.
Thank you, Your Honor.
Thank you. Court calls it. Is that it for you? Always a pleasure, sir. Real Properties versus Timothy Stevens. That matter is dismissed on plain motion without prejudice. Where are you going? I thought I was done with you. What? All right. Thank you for taking care of that. Westbrook Apartments versus Malu Noor.
No, we're here.
Okay, do you have a camera? As well as
Yes.
Isra Bazi. Thank you. Right, yeah.
Good afternoon, Mark Roethlisberger, appearing on behalf of plaintiff.
All right. And where are we on this case? There was supposed to be $1,600 paid.
We have not received any payments since.
Well, hold on. I may be looking. No, that's right. That's right.
Plaintiff has received no payments since a $200 payment was made on April 24th, which preceded our last appearance.
All right. What happened, folks?
My check was delayed. I can make 600 payment now. We did also get approved from Michigan Bridges for 500, and we have a Hawk appointment the 14th.
Okay, but last time we were here on the 26th, you had indicated you were going to pay $1,600.
I said $400 for a week, and that same day I said 100. I didn't say 1,600.
My note reflects 1,600, but how much is, what do you have as the current balance?
Judge, presently showing $4,560 unpaid rent, $187 in court costs. Total to retain will be $4,747 even.
4,007. Say it again.
$4,747. 0 cents.
4747.
Yes.
4747.
All right, folks. I mean, I don't know. You said you had what, DHS, an SER payment?
Yeah, they approved us for $500.
And Hawk, we have an appointment the 14th.
The 14th, but
Yes, so 4 days.
well, Right, but the problem is that with Hawk, that's county money and they're out of it at this point. Their funds are depleted, but I mean, there may be other agencies which will pay, but I don't see how we're going to do this. And, you know, you said your check was delayed, but even if you paid the 600, that's still, we're at 4,100 at that point. And you got the 500, but you'd have to make up before that 500 from DHS is paid, you have to pay the balance. So the reality is, even if you qualified, I can't even tell you if you did. And if they had money, you'd get 3,000 from there. You'd have 500. You pay the 6. We're still short.
I mean, we're both working now. It was just Ezra working for a while. We're both working. We can make as best payments as we can.
No, young ladies, I understand what you're indicating, but the problem is I can't even if I could cajole counsel and the plaintiff to do something different, I can't even go to them with that because I can't make the math work. I just can't. I think I'm pretty good at it, but I just can't make it work where you would even be able to get this clear before the end of the month. If I were even thought of trying to find a way to work that out, it's. And then how much is your monthly rent?
1,600.
So,
And that's one of our concerns. It's right back to square one.
yeah, I mean, well, or even worse, because
Well,
this other amount's not going to be paid.
Unfortunately, this has been an ongoing issue for a number of months, Your Honor.
All right.
Even preceding this court case, we were here previously in another situation. So this has been ongoing for long over half a year.
All right. Young ladies, if I issue a judgment to them and you guys can't pay it, what are you guys going to do?
I mean, I don't know what that means, to be honest.
Okay.
Um,
So that
Like,
the way that this
with the,
go ahead.
I was just gonna say, I don't know, how much time would the judgment give?
Okay, normally what the judgment gives is the judgment gives 10 days. So if I gave them a judgment today, they could attempt to, well, they wouldn't be able to do anything for 10 days till the 20th of this month. But then after that, they could file what's called an order of eviction with the court for my signature. And then once that's signed, the best I can tell you is that you're operating on borrowed time.
Judge, and I can say this. I just spoke. I have a representative for my client here, and I just spoke with the judge. I could extend the writ date out to May 30th. I can give them an additional 10 days beyond the 10 days.
Gotcha. All right, look, I think, young ladies, it's time. I don't know the current situation that you're in. I don't think you can afford to live where you're living. I mean, I hate saying that to people, and I hate telling them that, you may have to move and whatever, but I think that's where we are with this case.
Okay, I appreciate your honesty. I just have a question.
Yes, ma'am.
Let's say we do move by May 30th. Can I ask what would happen after that?
What do you mean?
We have till May 30th to pay it or move. Is that what that means?
Yes, you would, if they've graciously given another 10 days. You would have till the end of the month, in essence, to pay or move.
Would it be an eviction after, like on our record, if that's the case, or?
If I issue the judgment, yes, there's going to be an eviction on your record. It won't be so that you know they didn't request. There won't be a money judgment, something that necessarily follows you around. But the eviction, the judgment itself would follow you.
I will indicate for the record, and I can't make any promises, but frequently my clients, if they can recover possession, are not disagreeable or are sometimes agreeable to setting aside a judgment if possession is turned over on a recorded date that's been agreed to and it's turned over in good condition. So the possibility exists. I can't make any promises to you ladies, but if you do vacate by the 30th, don't require my client to incur additional court costs and the property is turned over in good condition, my client may be willing to set aside the judgment so that it's not in your record any further. You could reach out to my office after you vacate and I can talk to my client.
You understand that?
Kind of.
Okay.
sorry.
What don't you? I want to make sure you understand, huh?
His voice was a bit too far. If you could.
I'm
let us
sorry.
know. Your voice is clearer. If you could let us know.
Oh, okay.
Yeah.
So
It's kind of
here's
glitching.
what they're willing to do, which I have to thank counsel and the representative here because it's impressive. Not many landlords are willing to do this. But
Okay.
instead of, if I grant them a judgment today, instead of your move out date being the 20th, they're willing to make it the 30th. Okay.
Okay.
So that gives you additional time to try to get yourself situated. And then your next question was whether or not there would be a judgment on your record. But counsel's indicated that he can't commit his client to that. But sometimes what they've been willing to do is to, if you move out on time, leave the place in good condition and, turn over the keys and do everything in the right way, that they're willing to then set aside the judgment so that you then don't have a judgment on your record. He can't commit to that because you haven't moved out. But then he said that you should reach out to his office after you moved.
Okay.
Okay. And where's his office's
Okay.
information for us to reach out?
That should be on the
Paper.
pleadings that you received, the paperwork.
Oh, it's right there.
Okay.
Okay. We see it. All right. Thank you.
Are you guys you're going to be able to get yourselves situated, do you think?
If it's by the end of the month, yes, we should be able to.
You should be able
That would
to.
be great.
Okay.
We should be.
Well, you can thank the plaintiffs for that. I might have been giving you more time, but I don't know that I
Thank
would have
you.
been as generous as they have been in this. All right. So let's do this. I'll do this. I'll indicate that there's no tribal issue. I'm going to issue a judgment for possession. The total amount is $4,747. That would have to be paid on or before the 30th of May, 2024, or writ or order of eviction could issue. Okay?
Okay.
Any other questions you have? Oh, you muted yourself. Okay, you're good now. You have any other questions?
We're good. Thank you.
You guys are welcome. All right.
Thank
And I
you.
wish you all the best. Okay.
No.
Thank you.
Good luck, ladies.
Thank you, counsel.
Well, Rick.
You do the same. Carol Hall versus Don Lindeman and Jacob Gross.
Ready, Your Honor. I'm not able to turn on my camera for some reason. Technology, gotta love it.
Just pass it.
There we go. Good morning, Your Honor.
Yep. Good morning. You're not in the camera, but that's okay. Good
Oh,
morning.
goodness. Is this better? Oh, my.
It's okay. No, there
Here
you
we
are.
go. Hi, good morning.
Hello. All right, Miss Dawn Lindeman, I think she's here. Okay. Yeah, you'll need to unmute. Okay, what's the claim in this
Am I
case,
unmuted?
Miss Bassett?
Yes, Your Honor. This is a family tenancy. My client has allowed her niece to live in the family home, and now she has asked her to move. They have not moved out. We served the 30-day notice to quit. There is no money judgment being requested in this matter.
Yeah, it is a 30-day, but they marked this non-payment. Okay, all right. Miss Lindeman, what?
Yes. Hi.
Go ahead. What do you have to say about this?
Hi. We have a family agreement as it stated. We have only had a verbal agreement as well as cash payment at this time. I would like to seek further counsel if that's able to. We are currently moving out of the residence right now. We just need a little more time
Okay.
and some counsel.
Let me ask you this. You want to seek an attorney. Is that the deal?
Yes, please.
All right. I can give you 1 week to do that. Is that going to be enough time for you?
Yes.
All right. I'll adjourn this out. Statute to May 17th, 2024 at 2 p.m.
Okay. That's a Friday,
Okay.
correct?
Pardon?
1 week Friday at 2 p.m.
Yes. I'm here every
Okay, well,
Friday doing this. So.
Will I receive more paperwork for a new login for Zoom? Is that how that works?
No, well, no,
Same.
you can use, actually, those are technically in person, but if you want to zoom in, you can zoom in.
Okay.
You'll use the same login that you used today.
Okay.
All right. Thank
Okay.
you.
Thank you, Your Honor.
Arbor One West versus Asa Robertson, excuse me.
Good morning, Your Honor. Cheryl Wolkoff on behalf of the plaintiff.
Robertson, are they here? No. They have not checked in. Would you like to take a default?
I would, Your Honor.
All right. Do you solemnly swear or affirm testimony you're about to give will be truth, whole truth, and nothing but the truth, so help you God?
I do.
Go
Your Honor,
ahead.
plaintiff moves for entry of a default judgment of possession only, rent to retain possession, $848, court costs $175.10 for a total redemption figure of $1,023.10 and a writ date of May 20th, 2024.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ issue 10 days. Arbor One West versus Marquise Kennedy.
Cheryl Wolkoff on behalf of the plaintiff.
Has not checked in. You may proceed.
Your Honor, plaintiff moves for entry of a default judgment of possession only, rent to retain $1,584.83. Court costs $175.10 for a total redemption figure of $1,759.93 and a writ date of May 20th, 2024.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ issue 10 days. Arbor One West versus Gwinnetta Artis.
Cheryl Wolkoff on behalf of the plaintiff.
Did not check in. They are not here. You may proceed.
Thank you, Your Honor. Plaintiff moves for entry of a default judgment of possession only, rent to retain $2,246. Court costs $175.10 for a total redemption figure of $2,421.10 and a writ date of May 20th, 2024.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ issue 10 days. Arbor One West versus Latasha Taylor. That matter is dismissed on plaintiff's motion without prejudice. Arbor One versus Justin Mason.
Cheryl Wolkoff on behalf of the plaintiff.
Justin Mason.
I'm present.
I'm not
My
picking him up.
camera's having a bit of difficulty. Apologies.
Oh, there he is. The whole box didn't light. All right. Well, you work on the camera issue. How much is owing on this case, Ms. Luckoff?
Your Honor, total including court costs $2,671.10.
Mason, how are you intending on paying that?
I currently get paid bi-weekly, Your Honor. I just got paid today, and I don't get paid today on the 24th. So my plan was to submit $1,250 of that current balance today, and
1250?
$1,250 today, yes. And on the 24th, clear the rest of the balance, so I will have time to pay June's rent on time.
Okay, so here's what I'm gonna do. I'm going to adjourn this out 1 week to 5/17/2024 at 3 p.m. You're to pay the $1,250 to the landlord.
Okay.
Okay, and then we'll look at the rest of it come the 17th. I want you to understand that if you do not pay that $1,250, I'm not going to hear any excuses. I'm going to grant them a judgment.
Understandable, Your Honor.
Your
All
Honor,
right.
I would request, based on there's no tribal issue here and the defendant is agreeing that he owes the rent, we just take a judgment today and give him the time he needs. Give him till the 24th and then take it off the docket.
I'm going to do it.
That's
I'm going to
fine.
do it. I'm going to
Okay.
set it on the, I want to see if he indeed does
Okay.
pay.
Okay.
All right. All right.
Thank you.
Thank you. Arbor One versus Nicole Parrish.
Carol Wolkoff on behalf of the plaintiff.
You'll have to
Oh, I
unmute.
am here. Yep. Hello, I am here.
Okay. Hello. All right. What is the claim on this case?
Your Honor, the total balance $2,241.10.
Ma'am, how are you intending on getting this paid?
One, I'm working, so my check comes in on the 23rd. As well as I would like an adjournment. I am seeking legal assistance through LSCM. And I'm already speaking with a legal assistant there. And I would like time to apply for rental assistance as well as an adjournment to get more legal assistance and be able to have time to fill out a written non-payment answer form and return it to the court.
Read that very nicely.
I'm not reading anything, but there's a lot of problems. We've had a hole in our bathroom, and our bathtub has been unusable now for 2 months, and they have been well aware of this situation. And it was not
All
our.
right, ma'am, I'm going to grant your adjournment for a week.
Okay.
May 17, 2024, 3 p.m. All right. And if you're going to have an answer in or any financials, you need to have it to the court by this Wednesday.
Okay.
Understood? Thank you.
Thank you. Have a good day.
Six Trails versus Denisha Tatemore.
Cheryl Wolkoff on behalf of the plaintiff.
Not here. You may proceed.
Thank you, Your Honor. Plaintiff moves for entry of a default judgment of possession only, rent to retain $2,231.71. Court costs $181. The total redemption figure $2,412.71 with a writ date of May 20th, 2024.
Judgment to the plaintiff. That is by default for possession, redemption amount, in the amount requested with the writ issue 10 days. Six Trails versus Case, Six Trails versus Rose. Those matters are dismissed on plaintiff's motion without prejudice. Is that it for
Thank
you?
you very much. Yes, a little too easy. It's making me nervous, but
Yes, me too. All right.
great weekend, Your Honor. See you next week.
You do the same.
Thanks.
Take care. Okay, Pat McLaughlin versus Daryl Daniels.
Just so you know, this is actually a
Second. Yeah, I see that.
Your Honor, plaintiff.
Your name? All right. Where are we on this? You guys are trying to work with each other, I think, and
Yeah, we met yesterday. He paid 600 and we agreed he owes another 345. That's 225 in rent and 120 in costs.
I can,
so if you, the three, what'd you say, Mr. McLaughlin? 3, 4. So if he pays that, we're good.
I can pay that by Thursday, depending on when the money comes from my time, from my job. If it latest be Friday, but I pay it by Thursday.
Of next week?
Yes.
You sure?
Yes. I can pay every week.
And you believe it? I don't know. All right, no, listen.
They
Yeah.
supposed to be. They contacted me yesterday that they had money for me.
They did?
Yeah. And so I have they said it would be by today they would have money.
Because a lady from Friends Indeed was willing to take on this situation, to just take care of.
Okay, hold on a second then. Amy, are you there? I know that sounded like a call of distress.
Good morning, everyone. I've been here.
Okay.
That was the 5 I needed.
Do you know anything about Mr. Daniels?
Your Honor, I would like a minute to look up his
Okay.
information. Thank you.
That's fine.
Could I just clarify who his caseworker was? That he's
Do you know who your caseworker was?
I can't remember the name.
He can't remember the name.
is it Autumn or Alicia?
I think so, because I
Autumn or Alicia?
yeah, I faxed him all the information.
Okay.
Email it.
Mr. Daniels, those are alternatives. Is it Autumn or is it Alicia?
Maybe Alicia.
Maybe Alicia. He's not sure.
Right here.
We gave him a choice of two and he still can't get it.
One more question. What is just the year of your date of birth, sir?
The year of your date of birth?
1966.
1966.
Right, Mr. Daniels, I have permission to share some information that may be of some relevance to this case today in the court.
Sure.
Said sure.
Okay, thank you. So he was supposed to be working with Alicia, and looks like there's been some issue with actual document sharing. Which indicates that even if he is qualifying for the programming, I am not sure if the high funding ran out this week. So there may be one or two other things that Miss Alicia might be able to try to qualify for him, but whatever may have been indicated in terms of a larger amount of money, I do not believe that is something that he can rely on for today.
Gotcha. All right. But you say you can pay it.
Yeah.
Okay. Then let's not worry about it. Let me adjourn this out to the 17th, 2024 at 2 p.m. You guys, if you guys get it worked out, because you guys are working together, meeting, if you get him paid, then I just need a dismissal, or if you guys don't show up, then I'll know that I'm just going to dismiss it out. How's that sound? All right. Thank you, folks. Spice Tree Apartments versus Brandon Cole. Mr. Cole?
Yes, sir.
All right. He's here. What's the claim in this case?
Total with cost, Your Honor, $1,568.92.
And Mr. Cole, how are you intending on getting that paid?
On Monday, I had went up to the office and talked to Carla, and I gave her $1,500 on Monday. So I'm not sure if I owe another $1,500, but
okay, hold on.
Yes.
Stormbert, 1,500.
Actually, 1,530 was paid on. I have it on the 7th. Maybe he dropped it on Monday.
Okay.
It was paid on Tuesday, but
Okay, so you still owe the other 1,568 here.
Yes, sir. So on Monday, this coming up Monday, I was gonna go to the office and give her another 500, so that I will put it at 2, and then get that other 1,000 probably within like a week or so.
All right, so here's what I'm gonna do. You're gonna pay 500 on the 13th.
Yes, sir.
All right, since you made that payment, I'm gonna adjourn it out a week. All right, if that 500 is paid, then we'll look at trying to get you resolved. If not, I'm gonna give them a judgment. Okay?
Yes, sir. Yep.
If you get the rest of it, if you can get the rest of it in before next Friday, that'd be great. But
yeah, yes, sir.
We'll look at it, because that'd be about $2,000 you put down in a couple weeks.
Right.
So, okay.
Yeah. Yes, sir.
So I'll adjourn this out to the 17th at 3.
Awesome.
Okay.
Would I,
see what you can get paid in excess.
Huh?
Okay.
What'd you say, Judge Simpson?
Oh, what I was saying is make sure to get the 500 in, and if you got some money that you can put toward it, put toward it. Let's see if you can do that too, okay?
Yes, sir, definitely. Yep.
All right. Okay.
I got
take
one more
care.
question. I got one more question.
Yes, sir.
Sorry. When I come back in a week, do I just do the same thing I did today with the Zoom, like the password and the
Yep.
ID?
I'll let you.
All right.
Yeah, you can come in through Zoom.
All right, cool. Appreciate you.
Spice Tree versus Ashley Alexander. Not chicken. You may proceed.
Thank you. Your Honor, there's rent to retain of $1,649.81, cost of $172 for a total due of $1,821.81. And we'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue 10 days. Spice Tree Apartments versus Lauren Eccles. Oh, okay. Well, let me pass it and see if she'll come back. Spice Tree Apartments versus Christine Gray and Derek Cheatham. Gray and Cheatham's, they're not here. You may proceed.
Thank you, Your Honor. There's rent to retain of $1,678.27, cost of $214 for a total due of $1,892.27. And we'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue 10 days. Recall the case of the Spice Tree versus Eccles. Ms. Eccles, can you hear us?
Yeah. Hello?
Can you hear us, Ms. Eccles?
Yeah.
Okay. Council indicated that you owed $3,293.92.
I can pay $1,000 by the end of the day. I also reached out for renewal through SCR, so I'm waiting on a decision from them. But I can also pay another $1,000 within the next week.
So you can pay $1,000 today and then $1,000 within the next week?
Yes. And then
Okay, so you're gonna pay $1,000 today. Can you get that other $1,000 paid by the 17th?
Yeah.
Okay, so what I'm gonna do, I'm gonna give you a shot to get that in, and then we can figure out how we're gonna get the rest of this paid. But I'll adjourn this out. You pay $1,000 today, get $1,000 in. If you can get it in by the 16th, I'd appreciate it. But try to get it in certainly by the 17th. I'll adjourn this out to May 17th, 2024 at 3 p.m. Okay?
Yes, thank you.
All right, thank you. And if you don't pay it, I'm just giving them a judgment. Spice Tree Apartments versus D'Amico Hargrove.
Hi, this
Kenyatta Cross.
This is her. D'Amico's not here.
Okay. What's the claim in this case?
With cost, Your Honor, $3,885.27.
How's that going to get paid?
So I had reached out to Carla, I believe, on Wednesday. I had lost my job, but I just had an interview on Monday, and they're supposed to be giving me a call today. If everything goes good, I'll be starting by Tuesday. Carla told me to just let you guys know that she's willing to make a payment plan with me, but she told me to just come to court first. I have did an SCR and reached out to some agencies for help. And I have an appointment with Hawk, but once I get working, I'm gonna make those payments that me and Carla arrange.
So you say you worked out something with the landlord?
Yes, she told me to come to court and then call her back today and let her know what you guys say, but she said she's willing to do like a payment plan with me.
And Your Honor, I'm not aware of that, but if Ms. Cross and management work something out, then my plan would be to commit that to writing for submission to the court. Hopefully we can get a resolution in place.
All right, so I'll adjourn it out. Ms. Cross?
Yes, sir.
You said that you applied for an SER?
Yes, sir. And I have an appointment with Hawk May 26th.
Right. I think they may be out of funding currently. There might be some there, but how many people are in your household?
It's 2.
Okay. So understand that if that SER is approved, that's only going to be about $500.
Okay.
So don't bank on that. Okay.
Yes, sir.
All right, here's what I'm gonna do. I'm gonna let you talk to the landlord, see if something can be worked out where
Okay.
council knows what's going on too. So I'll
Okay.
adjourn it out 1 week. The 17th at 3 p.m.
Okay. Okay, thank you.
Spice Tree versus Brian Meeks. I think he's here. And Sissom Williams Meeks. All right. How much is owing on this?
Your Honor, this case is actually a dismissal. And I don't
Oh.
know if one's made it to the court file yet, but we do have this as a dismissal. Mr. Meeks, that's correct. You did make a payment to the landlord?
Yep, the day after this was filed, actually.
Okay.
I
Yeah.
just came just to
Okay,
be.
so Mr. Meeks, you don't have a problem with me dismissing this, do you?
I mean, if you want it, no, that's fine. That's totally fine. Thank you. Thank you, Your Honor.
Case is dismissed without prejudice. You have a great weekend.
You as well.
All right. Spice Tree Apartments versus Lindsay Ronald. They are not here. You may proceed.
Thank you, Judge. There's rent to retain $2,655.26, cost of $214 for a total due of $2,869.26. We'd ask for a default possession only judgment with writ to issue after 10 days. I would also just note for the record, Your Honor, there is a second defendant, Teresa Ronald, as well.
Yes, Teresa Ronald. They're neither are here. All right. Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue 10 days. Spice Tree versus Chloe Delory. That matter is dismissed on plaintiff's motion without prejudice. And I would recall Spice Tree Apartments versus Vaughn. Did she appear back in? She did not. She did not come back. So I'll let you take a default. You may go ahead.
Thank you, Your Honor. There's rent to retain of $1,262.56. Costs are $172 for a total due of $1,434.56. And we'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue 10 days. Wow.
Yeah.
That was quick.
It
All
was,
right.
Judge. I'll see you this afternoon. Thank you.
Yes, ma'am. Take care. 14A, stand in recess. Officer Mikowski? You on?
Yes.
That probably wasn't you. Somebody tried to. How you doing, sir?
Good. How are you doing, sir?
I'm doing well. All right. Can you raise your right hand? Do you solemnly swear or affirm the information contained in the search warrant and affidavit is true to the best of your knowledge, information, and belief?
I do, sir.
All right, fantastic. I will sign off on these. We'll get these right back over to you. And stay safe out there, please.
All right. Thank you, Your Honor.
Thank you.
Thank you, sir.
Court does call the case. Michelle O'Meara versus Jason Gold. And also On-Site Solutions. Good afternoon.
Local planning, P69690 for Lincoln.
All right. And,
Hi, Michelle O'Meara.
okay. Are the Gold, is Mr. Gold or anybody from On-Site here? Do you know?
Mr. Gold was not at the first hearing and neither was On-Site Solutions.
They were not. Would you like to take a default?
I would, Judge. This is a request to shorten redemption.
Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I do.
All right, go ahead.
Judge, this is a request to shorten redemption. My client Michelle O'Meara purchased the property at a foreclosure sale on February 20th, 2024. We have the recorded shares deed attached to our summons and complaint. We named Mr. Jason A. Gold as he was the mortgagor, and On-Site Solutions as there is a judgment lien as it relates to this property. It indicates that the debtor is Maya Gold, but it lists Jason Gold as the defendant as well. So as the judgment lien goes with the property, I wanted to make sure I named On-Site Solutions as well to give a notice of shortening redemption. We did send a proper notice to Mr. Gold requesting an inspection. He contacted my office and would not allow an inspection for approximately a month and a half. The statute requires 72 hours notice. My client gave 13 days notice, then agreed to extend that for another week. He did not respond to my emails. So we moved forward with this complaint. He did not appear at the first hearing. He is not here today. I confirmed with your clerk that notice was sent. We asked for a default judgment with the writ to issue immediately. We requested that in our complaint. My client is here for the court wants to take testimony that the door is ajar, the screens for the windows are broken, and there's some damage to the property, and grass is extremely overgrown.
Everybody's grass is overgrown, so I can't hold that against them. It's just been the weather this year. Anyway. Okay, not that. Okay. Judgment to the plaintiff, that is by default for possession. There is no redemption amount. I will issue a writ immediately. I will also under 4201H, I do believe it is, still permit also immediate entry to the premises by the plaintiff to secure the premises prior to the eviction process going forward.
Thank you, Judge. I did fill out 4B with the writ to issue today with the 10-day appeal period at the bottom to be made effective. I have signed it.
If you would include that the plaintiff may enter the premises to secure it pursuant to the Michigan court rule. And then that way you can go in, you can secure the front door. If you want to mow the lawn, you can mow the lawn. In fact, if you mow the lawn, you can come by mow my lawn. Because I'm sure it grew between now and last weekend. That's it. All right. I've signed the judgment. Good seeing you, counsel.
You as well. I haven't had a case with you since COVID, Judge. If you believe that.
Has it been 4 years? Jeez.
Judge, I'm going to ask my client to go ahead and get a writ prepared down at the clerk's office.
If she pays for it, I will sign it today. I'll be here.
Appreciate you, Judge. Thank
All
you.
right. Thank you.
Thank you so much.
Thank you.